Okay, so I have a comment that I read today on a LinkedIn post. I won't mention who it was, but it was really interesting. There was a discussion going on LinkedIn about the the coronavirus stimulus package and what some of the challenges are that people in the intellectual property space specifically are facing. You know, there's a lot of people facing a lot of different challenges right now. But one of the suggestions that was brought up was that the USPTO would be able to help out by allowing no-cost extensions for statutory deadlines and waiving those maintenance fee surcharges. And I don't really know what the sentence that I just said means, but I thought it was really interesting. So I sent it to you earlier today, and I was just curious to know if you had a chance to look at that and what your thoughts were. So
I did. And number one, I know the guy. I'm not going to mention his name because I don't know how he'd feel about that, but he's really bright, and it's a good idea. So here's what his idea is. I mean, I think it's a good idea. So here's his point. What are people strapped for right now during this crisis? Cash, right? I mean, during any crisis, cash is king, and companies are trying to conserve as much as they can. Now, let's say that this crisis lasts for another, 4 months. Could be 4 years, could be 2 months. I don't know, it could be a month. I have no idea. None of us do, or at least none of us regular people do. But let's say it's 4 months. Well, being able to conserve cash for 4 months could be good, right? And what he's saying is there's a way the USPTO can help. And here's what he means. So he's saying no cost extensions up to the statutory deadline. When you are involved in patent prosecution, and patent prosecution is essentially the back and forth between the inventor, which means between the patent lawyer and the patent examiner on coverage with respect to your patentable idea. So the patent lawyer is trying to get his inventor as broad a coverage as possible. And the patent examiner is trying to make sure that the invention, the claims of the patent are no more broad than the prior art allows, right? So without getting into so much detail on what that means, essentially there's back and forth. There's a response to, so the patent office will give an office section, which might say your claims are too broad, you need to narrow them. And then the patent lawyer will submit a response to that office action. But there's all kinds of other office actions as well. In fact, patent prosecution is so much about office actions, back and forth between the lawyer and the patent office. But you get 3 months to respond to a patent office action with no fee. So if you respond in the first 3 months, there's no fee. But in months 4, 5, and 6, there are increasing fee amounts. So if you wait until the 6th month to respond, you're going to have a pretty big fee that you have to deal with. Mm-hmm. So one of John's ideas is, why don't you let us respond up to 6 months with no fee extension or with no extension fees, right?
Right.
So we could keep cash in our pocket and keep prosecuting along with patent applications. Because in my experience, there's a lot of situations where people go beyond 3 months. And that's a big number overall for the USPTO. So I could see the USPTO's point of view, which is, hey, we need that money, and that's a big revenue source for us. But since it might only be a 3 or 4 month crisis that we're dealing with, those extensions could mean a lot to companies.
Right.
And then the second thing he asked about was the, I think it's the surcharges on maintenance fees, right? So basically what that means is this. I file a patent application, and let's say, excuse me, by the way, did you see how I coughed into the crook of my elbow?
Smooth, yeah. I think I touched my eye like 3 times this.
Yeah, and normally it's like 30, right?
Yeah.
Yeah, I mean, but anyway, so normally, or if you get a patent issued, it's granted, you then, every so often, you have to pay maintenance fees. In the US, it's 3.5 years, 7.5 years, and 11.5 years. You have to pay maintenance fees. And if you don't pay your maintenance fees, your patent is basically expired. It's unenforceable, right?
Oh, really?
And a lot of people do that. They might file their patent application, maybe pay the first maintenance fee, which is lower. The prices go up as you go. 3.5 is less than 7.5, which is less than 11.5. And people will say, wow, I thought this had a lot of market potential when I prepared and filed my patent application and even during prosecution. But now that I've had it for a couple of years, I'm seeing it's just not useful to me. I'm not going to keep paying the maintenance fees. So you stop paying the maintenance fees and the patent expires, essentially. It's not enforceable anymore. But if you miss your 3.5-year maintenance fee, you get a 6-month window, or your 7.5, or your 11.5. There's a 6-month window in the US where you can still pay your maintenance fee and maintain the validity of your patent, but you just have to pay a fee. You have to pay a surcharge, right?
Right.
So what John's saying is, and this is an even more valuable idea, let's waive that 6-month surcharge. Because what does that do for us? It enables us to wait 6 more months before we pay the maintenance fee, right? This crisis might only last for 4 or 5 months. And if that's the case, a 6-month extension and having to pay the maintenance fee is a lot. That could be a lot of money, because don't forget, these big companies, they might have 30 or 40 or 50 or 100 or 1,000 patents that they have to pay maintenance fees on at a particular period. Right. If they could hold off 6 months and not have to worry about a surcharge, that could save them a lot of money. Now, if they have to pay the surcharge, they'll just pay the fee on time. But if they could wait 6 more months before they have to pay the fee, they'll have to pay anyway, it could really help them through this crisis. So I like that idea more than the not paying fees for extensions of time on office actions. I only say that because you have one remedy to the first idea of not paying fees for extensions of time, and that is pay within the first 3 months, right? But if you can then hold off that as well. So even as I'm talking about it, I'm realizing how stupid what I just said is. It really is stupid what I just said. Both ideas are good. Why? Because the first idea enables you not to have to pay. Oh no, let me take that back. It wasn't a stupid idea. It wasn't stupid what I just said. See, you caught me here. I'm trying to process this in real time.
Yeah, it's okay.
You could still pay. You could still file your office action within 3 months and not have to pay a fee. So you're really not pushing off any charges in that case, unless of course you're not paying your patent lawyers and you want to hold off paying them for another 3 months. But then, of course, they're suffering. But so I really like the second idea better, which is just don't make us pay our maintenance fees for another 6 months, and we won't have to pay an extension, because then we can conserve cash for 6 more months. And again, 6 months might be the difference between during the crisis and the crisis being over.
Right. Yeah, that whole concept, and thank you for explaining that so clearly. But because it made me realize 2 things. One, just on like an IP business implications standpoint, you might file a patent that you're essentially just trying to create, I think, a patent fence, right? So you're trying to prevent your competitors from making something that you might have no intention of making, right? Or potentially, I don't know if that's exactly a patent fence, but you can do that, and then the business decision that you have to make is the cost of paying those maintenance fees lower or higher than the cost of potentially having to compete with someone in the marketplace who is going to produce that product, or if somehow their product might impede on the market for a similar product that I'm selling, right?
Yeah, okay. Let me just stop you, because I don't want to spiral too far out of control, okay?
Yeah.
So let me explain what I mean. So you mentioned a term that I just have to explain, because I don't want people to get confused about this. A patent fence, okay? You don't file a patent to create a patent fence. And what I mean is, it's a highly inefficient way, in terms of cost, to create a patent fence. A patent fence is essentially this. You have a patent, okay? My main competitor, Ray, has a patent on something that's very broad. Let's say you have a chair patent, and your chair patent claims an apparatus for sitting comprised of a back, a seat, and 1 or more legs. Okay, a back, a seat, and 1 or more legs. That's a really broad patent, right? Now, you couldn't actually get that, because that's already been out there for longer than the beginning of time, right? But anyway, I don't know when the chairs were invented. But anyway, you couldn't get it. But let's say you could. And I'm in the business of chairs. That's a great patent. And you now dominate the patent industry because none of us can make chairs that have a back, a seat, and one or more legs without infringing your patent. But what we could do is create a patent fence around you. And that is, we fence your patent in. We create patents or chairs with footrests and headrests and armrests and wheels on the bottom and laser beams that shoot out of the armrests and all kinds of stuff, which are features in chairs that your customers want to have. So a customer might say, well, look, I like your chair, Ray, but I really want the one that has the footrest and the headrest and the armrest and the laser beam that shoots out of the armrest. But I've created a patent fence, not by patenting those features necessarily, but by publishing those features. I could publish, or I'm sorry, okay, you know what? We're doing this in real time again, and I'm totally getting this backward. Let me try that again. I could patent those features and create a patent fence around you so that you have to license from me to get those features, right?
Yeah.
You have to get those features from me with the license. So it's true that I can't sell your chair with a back, a seat, and 4 legs without getting a license for you, but you can't sell your chair with a footrest or a headrest without getting a license from me, right? So
Right.
I've fenced your patent in. The way that you can protect your patent fence, the most cost-effective way to prevent a patent fence that you would have is publishing all around it, right? So if you have this great patent and you want to prevent me from patent fencing you, you could then publish all around it and prevent me from patenting it all. So that's really a patent fence, is putting patents around your patent to prevent your patent from dominating my commercialization. The way you could prevent a patent fence is by publishing all around your core patents so that I can't get patents. So now let's get back to the topic, which is, why would you pay maintenance fees? The only reason you'd pay a maintenance fee is if you felt that you could get a patent to patent fence someone else's patent, right? And you probably want to pay your maintenance fee in that case. But if you're just getting patents to protect your own patent, you'd probably just publish instead, so that you could prevent people from getting patents, and then you probably wouldn't get a patent in the first place. But,
okay. Now I see how that's different than what I said. Now I understand. Yeah.
So
if you were trying to fence someone else in, you might.
It's valuable.
Patent. But if you were trying to protect yourself, you'd publish, because why would you patent if you already have the patent? Because they can't make the stuff that you're publishing on anyway, because you have the patent.
Exactly. You've basically salted the earth, if you will.
Yeah. That's
around your patent.
The scorched earth mentality.
Scorched earth all around your patent. So then you keep the dominant positioning and nobody can patent fence you in, you know?
Right.